Well, I'd love to start out by just thanking all of the panelists for being here. My name is Colleen Mullen. I am the Director of Pro Bono at Legal Services of North Florida, and I am thrilled to be joined with my panelists today. We have Phoebe Lemaire from 211 of the Big Bend. We have Ken Kent from the Leon County Clerk of Courts Office. We have Judge Monique Richardson, who is a county court judge here in Leon County and also formerly an LSNF attorney. And we have Ian White of Ausley McMullen. So, Ms. Lemaire, you ready to start us off by telling us what 211 of the Big Bend can do to help landlords and tenants?
Yes, I can. And let me share my screen. So hello, everyone. My name is Phoebe Lemaire, and I am one of the hotline counselors at 211 Big Bend. So in terms of evictions, there are some things that Helpline 211 can provide, in terms of services that are in our community. So what does Helpline 211 do? So just as a brief explanation, we provide 24/7 access to information and referral to social service agencies along the entire Big Bend area. And we also provide confidential telephone counseling services. So that includes crisis counseling or even supportive counseling. To contact us, you can dial 211 or the following 850 number. We also have texting services from 8 to 5, Monday through Friday. And you can just text your zip code to that following 898-211 number. So if some caller, they called the hotline and they were saying that they're having some trouble and their landlord is trying to evict them or telling them that they have to leave, the first thing that a hotline counselor is going to say is that we're not a legal professional, but we're going to tell them that they cannot evict them without a court order. And especially right now, there is an eviction moratorium until August 31st. And we're going to also tell them that it's illegal for a landlord to lock them out, turn off utilities like electric or water, do other sort of quick fix things like removing the front door or taking other steps to force them to move. And we're also going to let them know that if a landlord attempts an illegal eviction, we would recommend that they call law enforcement or a lawyer if they have one to stop the threat of safety to the safety of their family. And of course, there is that exception that if a tenant poses a threat to their health, safety, and welfare of others. So I believe that's the only other sort of thing in terms of evictions that we can say. But in terms of referrals, there are some agencies that we can provide callers that help out with rent assistance as well as rapid rehousing. And so what rapid rehousing is, it's supposed to be a short period of time if somebody is homeless or they are about to become homeless. An agency can help them out with the deposits to get into a new apartment, any sort of moving costs, maybe first and the second month of rent, maybe turning on utilities. And then rent assistance is going to help out with past due rent. And so right now we have some new programs in our information database, such as the new funding from the CARES Act, and that includes Leon County and Jefferson, as well as Taylor County. The Community Action Agency has some rent money, Catholic Charities, the Big Bend Homeless Coalition, ECHO, Swanee River Economic Council, as well as the Calhoun Liberty Ministry Center. So I listed these out. However, there is some specific eligibility based on your location. So for example, Leon County wouldn't qualify for someone, the Leon County CARES Act funding wouldn't qualify for someone in Wakulla County. So if you want to know what sort of things qualify for your area, you could just call us. Some other referrals we could give callers are to the local homeless shelters for the Big Bend. This includes the Kearney Center. And right now, you may know that the Kearney Center's physical location is actually closed. What they're doing is they have a wait list and they're placing people into hotel rooms, such as the Suburban Extended Stay. And so the Kearney Center is for single individuals. It's not for sex offenders and it's not for families. So if somebody wanted to get onto that wait list to get into the Kearney Center, they would call the following intake line, 850-629-9270, and a case manager would call them back. And then the other sort of shelter in our area is for families, the Hope Community Shelter. This also has a wait list, and callers have to contact 850-792-9433, and staff would also call them back. If a caller is getting, is having some issues with their tenant or with their landlord, we have a few legal referrals we can provide them. Of course, to Legal Services of North Florida, to the Florida Bar's Lawyer Referral Service, the Legal Aid Foundation of Tallahassee, and Florida Free Legal Answers. And of course, just like with the rent assistance, eligibility is just gonna depend. So just call us and we'll help you figure out which one most applies to you. Another referral that we can give them is to something called norent.org. And this is an online letter creation tool, and it aids tenants who have suffered loss of income due to COVID-19. And it helps just get documentation in place. So on the right-hand side of the screen, you can see a sample letter from the website, and it's legally vetted by a nonprofit housing and tenant rights organization. And it also cites up-to-date legal ordinances. And so it's not necessarily legal aid, but it just gets that documentation in order. It's also free, and you can send it via email or certified mail. And so we do have a lot of referrals, but like I said, we also provide short-term crisis counseling. And I think this is really important, especially for people who are going through something like evictions, just to be asked how they're doing emotionally, because, we're all going through this pandemic, and, there's a lot of anxiety and loneliness going through that. But callers probably also have been without a job for some time, and they probably felt that frustration of trying to get funds for their rent, trying to get a new job, or trying to get unemployment assistance without a resolution. And so we think it's really important not just to give people the information, but to engage the caller's feelings and, validate what they're going through. We always say that, sometimes a stranger listening to you can be cathartic. Something else we can explore with callers is just exploring some alternatives, bouncing ideas off what they've done already, what they might have not done already. And so some alternatives we can provide is just contacting the landlord, asking to set up a repayment plan, and proving a loss of cause of income. And also, exploring saving on other spending, such as maybe applying for utilities assistance and putting part of the utility bill funds that they may have towards rent, going to food pantries to save money, canceling subscriptions, or any other expenses that could go towards rent. Some other alternatives could be donating plasma, selling unwanted items, contacting your local church, talking to family or friends, about staying with them for the time being, setting up a GoFundMe, or even buying camping supplies to live outside, if it does get to, having to leave your home. All right, so I know I went through a lot of information. Are there any questions currently from the Facebook Live? All right, none yet.
Oh, sorry, I was still muted. We have none from there. And we do have a few attendees via Zoom. I did want to let the attendees on Zoom know that you can always post a question on the Q&A during the presentation. We may wait until the end to answer your questions, but we promise we will get to them.
All right, I'm going to stop sharing now.
Well, thank you very much, Miss. I keep saying your last name wrong. It's Lamert?
Yeah.
Okay. I'm so sorry.
It's okay. It's always mispronounced.
I'm sure that is, but it's still not a good excuse. But we really appreciate that. And I think 211 is a fantastic resource, and anyone who's in crisis or in need should call and see what their options are, because 211 may be able to think of something that you haven't thought of yet. So I think you guys are doing great work, and I really appreciate it. And we do refer clients to you guys all the time, and I know you guys refer clients to us. So, so next up, we do have Judge Monique Richardson and Ian White of the firm Ausley McMullen And they're going to talk about the legal ramifications and the legal steps for eviction and what you can do to defend against evictions. Yeah.
All right. Good evening, everyone. Again, I am Monique Richardson. I'm one of your 5 Leon County judges. I handle eviction cases and review paperwork that comes in, all the pleading, all the answers, etc., and then set those matters for hearings when appropriate. Mr. Attorney White, you want to give some of your background?
Yes, Your Honor. Ian White, I'm a partner at Ausley McMullen. Part of my practice does encompass landlord-tenant. I represent landlords and tenants, so I do both sides. Most of my work is on the landlord side, but you kind of learn both ways. I also involved with probate and other types of work as well.
Right, thank you. And we want to thank Attorney White for taking time out as well to co-present with me. And I think what we're going to do is kind of hand this off to each other, this PowerPoint presentation, and hopefully get to the matters that people really want to hear about, which is how these evictions are proceeding right now. Let's see. All right, I think the first thing that I think tenants need to be aware of is what judges and lawyers are reviewing initially will be Chapter 83, which is the Landlord-Tenant Statute. Make sure there are 3 sections to that statute, and you want to make sure that you look at the one that references tenants as opposed to commercial or the third option, which in most cases doesn't apply, but you want to make sure this is residential housing section that you're reviewing. And we're going to kind of go over what notices you could end up receiving as a tenant, or if you're a landlord, giving, what filing a complaint looks like, making sure service of process is done correctly, and then we'll move on to how cases get set for hearings and any emergency stays of the writ of possession. So I'll go through the 3-day notice. This is actually an example of a 3-day notice, and there are lots of parts to it. And one of the things you want to make sure if you receive a 3-day notice, and certainly if you give a 3-day notice, is that you include all of the parts that Section 83 of the Florida statutes requires. And some of the ones that we definitely look for are, you want to include the amount that is being demanded. You want to make sure the 3 days that you're giving do not include holidays or weekends. You want to make sure there's an address and the landlord's name or the property name, so that the tenant knows where to send the money. If for some reason you end up paying partial payments and the landlord accepts it, then a new 3-day notice needs to be submitted and either hand delivered or posted. The other type of notice that we've actually been seeing a lot of since the moratorium began would be the 7-day notice to tenants. The moratorium only included rental payments. And so if you received a 7-day notice, it could have been because of some other reason that the landlord considered that you were not complying with the lease agreement. So that could have been things like owning a pet without permission, or having guests stay longer than permitted by the lease, causing property damage, etc. And this is the notice that you might see just prior to an eviction complaint being filed against you. Attorney White, you want to go over the complaint and let me know when you're ready for me to switch slides?
All right. So you want me to do number 8?
Yes.
Okay. On the complaint, it is important to make a decision when one is filed or whether you receive one. It'll either be a 1-count or potentially a 2-count complaint. one count. The first one's usually for possession, which has a different tracking period than the damages aspect. And so a summons, you'll be served with the complaint. Generally, the summons will say that you have 5 business days, which is exclusive of holidays and weekends, in which to respond to the complaint that you're served with. So it is very important that if you're going to have a defense, to get your written response into the court within that 5-day period. And then if there happens to be a count 2 for damages, you actually have a little bit longer. You have a 20-day window to respond to that. But most of the time, tenants that are receiving an eviction, the focus obviously is on the possession part. And if for some reason a tenant does not respond to the complaint of any sort, then before a default is usually entered, it depends on the way the tenant is served. And if for some reason the tenant is not served at all, and it's just posted, then the landlord will need to supply what's called a non-military affidavit to the clerk, along with their motion for default before the default would be entered in that scenario. But again, even in that situation, the clerk would be precluded from entering a money judgment against the tenant until that tenant either responds to avail themselves of the jurisdiction of the court or is served as an individual or substitute. And then finally, if assuming that their complaint is filed, it's been responded to or not responded to, at some point there may be a final judgment entered. And upon the entry of a final judgment, then the clerk would be directed to issue a writ of possession. Currently, I think we still have a few more days. There's a moratorium on writs of possession. And so until that changes, those that file evictions may be able to get up to the final judgment stage, but that's about as far as you're going to get at the moment until the moratorium is lifted. And at the moment, we are waiting on Governor DeSantis to decide whether it will be extended past September 1st. Currently, I think it's at 12:01 a.m. on September 1st is when the current executive order would expire. Going to the next slide, I may have covered some of this already, but the attachments to the complaint, it is important that if you are going to file an eviction due to non-payment of rent, again, there's a moratorium on those right now, but once that moratorium is lifted, you have to make sure you attach your 3-day notice that was presented a few minutes ago. That's a requirement. And if you are dealing with a 7-day notice violation instead, or sometimes it's a combination, but assuming it's just one or the other, you need to supply and attach that 7-day notice to your complaint so the court will see that the notice provisions were followed prior to going forward with the eviction. And the next, the lease agreement is imperative. I can't tell you how many times I've run across either partial leases that doesn't help the court very well when someone just provides, say, the first page and maybe the signature page, because there are important provisions within a lease. Everybody uses a different lease. So for the court to be able to administer their part fairly, it is imperative that the entire lease agreement be attached to the complaint, because sometimes you may, even if you're dealing with a 7-day notice, the 7-day notice may have alluded to specific sections within a lease that were violated. And if those are missing, then how is the court to determine and be able to read those paragraphs? Again, on the 2-part complaint that I mentioned earlier, if you are going to just go for possession, then just do the 1 count. But some of the folly that I see is where someone files a 1-count complaint and then later in that action is seeking damages. Well, if you only ask for possession, then you would have to bring a new action in order to deal with damages. So it's kind of a one or nothing. You have to make the decision up front whether you're going to do a 1-count or 2-count complaint. You got to make sure you pay the appropriate fees to the court. There's a different scale on that. In addition, the clerk then charges a $10 per summons to issue the summons. And then to actually get service, you have to deal with the sheriff, and the sheriff charges their fee of $40.
Or a private process server.
Or you can use a private process server. Their fees will fluctuate. So you can use a private process server, yes. You would just need to get with them and find out what their fee structure is. Some of them charge different fees based on how expedited you want the service to be. Go ahead.
I think one of the important parts to note, if you're a tenant, of all of the things that Attorney White said, that's just the beginning of the process. So just getting a 3-day notice, just getting a 7-day notice, there's so much that a landlord has to do before they can legally evict you. And so just be aware that there is a process, and it's pretty lengthy.
Florida is not a self-help eviction state, unlike maybe some other states. So it's very important that those notice requirements are followed, because you can get an eviction dismissed very quickly if you don't have those provisions in place.
All right, and Mr. Kent from the clerk's office, do you guys keep a list of available private process servers?
Yes, Your Honor. There's actually, we can provide a list. There's also a list on the Second Circuit's website. So if you do a search on Google for Second Judicial Circuit of Florida, you'll find that you can click on the approved process server list, and you can select from that list. You can contact those people and determine which one is best for your needs.
Perfect, thank you. The next section, Attorney White did cover some of this. This is process service. So your landlord will have to get you served. So for possession, it can either be personal service, meaning deputy sheriff or process server hands you the complaint paperwork and the summons, or if it's, again, just possession of the property that they're seeking, it can be posted. So not answering the door, or kind of dodging, posting it on the door of the residence is sufficient if the landlord is only seeking possession. And Attorney White did cover the fee as well. For damages, and I tell folks that come in front of me, damages doesn't mean just you broke the sink, but it means money damages. So it could be physical property damage, or it could be past due rent that's owed, sometimes attorney's fees if an attorney is hired by the landlord. All right. One of the things I think that's important to know is that if you, as a tenant, if you do not file an answer, if you don't respond in any kind of way, the landlord is going to get a default judgment. And default judgment means that you did not file an answer or respond in any way to the complaint. And you have to respond by filing something with the clerk's office. Just sending something to your landlord is not an answer. It's not sufficient unless your landlord is willing to file it on your behalf. And I rarely see that. So make sure you file an answer with the clerk's office. Right now, again, with the moratorium that's in place, if you are unable to pay your rent due to the result of COVID-19, meaning you lost your job, your hours were reduced, you want to definitely make sure you file an answer and let the court know that. Otherwise, again, a default judgment will be entered and the landlord will move straight to getting a final judgment and a writ of possession. One of the things that I wanted to highlight on this particular slide is the court is looking to see that there is a landlord-tenant relationship. So again, while people were kind of sheltering in place, quarantining, what have you. They may have had relatives move in that have refused to leave. That's a different process. And so that is called an unlawful detainer. So you want to make sure that the cases that apply here are just the landlord-tenant relationship, meaning you either had a written or perhaps even a verbal lease agreement, and that there was rent being paid in some way. I covered the partial payment earlier. All right, Attorney White, you want to talk about answers a little bit more?
Sure, let me get to that slide. So when an answer is filed by the tenant, the court will review that answer. And what I have found in the practice for Leon County is that the judge has been doing a really good job of looking at those, and sometimes they'll go ahead and just issue certain orders directing the tenant to act or perform a certain way. Could be depositing rent in the court registry, and it provides some deadlines. Assuming there is no judicial intervention right away, the landlord would need to then look at the answer that is filed. The answers are not always sent to the landlord, so it is important to monitor your case because sometimes they'll show up on the clerk's website and maybe you haven't received it yet. You would then need to look at it yourself as a landlord, and then because an answer is filed, the clerk would be precluded from filing a default. But if you believe that the answer is not legally sufficient, you always have the option of filing a motion with the court, asking the court to do a judicial default, and then go from there. If you're not certain, or say an answer is filed and the tenant then deposits the amount of rent in the court registry, then the court would then set it for a hearing on the matter, because one of the requirements that's on the next slide, that the tenant can only maintain their defenses if they deposit rent in the registry either right away or pursuant to a court order that will direct the tenant to deposit X number of dollars in the registry by a certain date. As long as they do that, then they can maintain their defenses and the court will hear those defenses. Just supplying an answer is not enough. So it's important whether you get an order from the court or not. If money is alleged to be owed, the statute does require that you deposit the amount of rent unless there's a determination of a different amount into the court registry, so that way you can maintain your defenses. Which slide are you on now? The judge? Okay.
The judicial review. And I think the important part, again, to remember from what Attorney White said, is that even though there's a moratorium in place, and I'm going to say a partial moratorium because it was changed fairly recently that extended it to September 1st, is that your rent is still technically due, right? So even though there's this moratorium in place and the judge is going to, set things for a hearing if you let them know that COVID-19 has affected your income and your ability to pay rent, that as soon as what the order from the governor says is that as soon as you are able and COVID-19 is not affecting your ability to pay, that money becomes immediately due. And so the court is going to likely issue an order directing you to deposit the past due rent into the court registry. And if you fail to do that, then again, the landlord may be entitled to a default judgment against you for possession. If the tenant does file an answer and the judge reviews and it appears to be something where an evidentiary hearing is necessary, the court will schedule a hearing, an eviction hearing on the matter. And it's important to know that the courthouse is closed to the public but these eviction hearings are happening. We do them every Monday and Thursday at 8:30 a.m. And we're doing them by Zoom, just like this presentation. And so it's important to make sure that you check with the clerk or the judge's office that is hearing the case to get their Zoom information, because if you don't appear, again, the landlord may be entitled to a default judgment.
Correct.
All right. We've talked about that. So the eviction hearing, I think, Attorney White, if you want to talk about from your end what an eviction hearing looks like, and I can talk about what we're looking for as judge.
When the, assuming that there is a response filed of some sort by the tenant, the clerk will, and assuming that the, if there was an order for the tenant to pay certain monies in the court registry, if that has been complied with, and the clerk usually, as part of the order, it already has a hearing date set within the order. The only way that hearing date goes away is if the tenant doesn't comply with the court order. But assuming that we go to a final hearing on the matter, that would mean the tenant has put in the monies that the court is expecting. And then those are usually set pretty quickly, or like I said, it's already embedded within the court order on a determination of rent. The parties would then be present via Zoom. Instead, it used to be in person. And I'm not as familiar with that process because I haven't had to do the Zoom yet, but I've been told that the way it would work is that they would be, you submit your information and then the court will be contacting you at the appropriate time. So you have to make sure that you're available. You have to block out that time so the court can then, when they're ready to have your case heard, that you're prepared and ready to present your various evidence. It is important to have your evidence ready. If on my side, even with the virtual aspect of this, it's important. I would make sure that I have papered the case and provided hard copies for the court, just in case technology fails us on a sharing situation. It allows the process just to move swiftly. So if you do have a situation where, especially if you have legal counsel on both sides, then as a matter of course, I would be providing all parties with copy sets of whatever evidence so they could follow along. And then at the end of the presentation of evidence, whether that be documents and or witnesses, then the court will then make a determination of the evidence that was put in front of them and then make their ruling.
These cases, evictions, at least the beginning part, the possession part, they move very, very quickly. And as Attorney White indicated in the beginning, you have 5 business days to file an answer as a tenant. And if a hearing is scheduled, they are done within 7 to 10 days. So you want to make sure that you're checking your mail. You want to make sure that you're staying in contact with the clerk's office and trying to find out if your case has been set for a hearing, because these move really quickly and that's required by statute. The other thing to remember about these hearings is that when a hearing is set, that is your time to present your witnesses, your documents, any receipts that you have, and you'll want to have that available to the judge in advance. The attorneys generally know how to get the information shared by emailing either the judicial assistant of the judge or sharing it on Zoom, like I'm sharing this presentation. Generally, tenants, we recommend that you file your documents with the clerk's office so that the judge can then look at them as you're talking about them. We do see tenants come in and they say, oh, I had my witnesses. I didn't know today was the day for that. Or I have receipts that I paid for that, but I didn't bring them. So the eviction hearing is the day to have your witnesses and your documents ready to go, because the judge will have to make a determination on whether to grant the eviction or not at that hearing. All right. If based on the evidence, an eviction is granted, the judge will typically go ahead and, unless the landlord has already provided a proposed final judgment, the judge will go ahead and sign that final judgment, making the eviction final. And again, just for possession. And once that is done, the landlord will have to submit a writ of possession to the clerk for the clerk to issue. Once the clerk issues the writ of possession, then the landlord has to get that writ over to the sheriff's office to be posted on the property that's at issue. And once that is done, the sheriff comes back 24 hours later to require the person to get out. It's important on the landlord side to know that the sheriffs do not actually move people out. You'll have to have a crew or yourself to actually move property out if for some reason the tenant refuses. The sheriff is there just to kind of keep the peace and make sure it goes smoothly. That's talking about that.
I did want to dovetail on something you just said, Your Honor. You know, at that stage where a sheriff is there there's a lot of stress that's going on at that time. And it's not uncommon if a tenant stayed in all the way through up to the sheriff. Something that I've counseled my clients on the management side to do is that, you know, there is some aspect that you want to work with them to a certain extent, instead of, even though the law says that once possession's changed over, you can just move their belongings to the property line, and then you're no longer having liability for the personal property. But depending on the relationship that the landlord has with that particular tenant, the landlord, I generally ask or advise the landlord, you know, either notify the tenant when they're going to move it, or if the tenant wants to come to the landlord and say that they can be there the next day to move it out, they're not getting new possession. But if they're going to marshal their own assets to move their belongings out, then that might be the better way to go, especially if there's a weather situation. The worst case scenario is to see something like that put out there on the property line, and then you get a torrential downpour.
Yeah, definitely. That's definitely good advice. And when we do these final hearings, we tell tenants and landlords that if they are able to reach an agreement, stipulate either to an extended period of time to stay or an amount that would allow them to stay a little bit longer, that is completely okay. Even after the court issues the final judgment, the parties can still reach an agreement that works for both of them. We just recommend that you file that with the court so that the court knows that y'all have reached a settlement agreement. So one of the things that we see often is after the final judgment has been entered for possession, in a lot of cases, it's situations where the tenant may not have attended the hearing and they find out about, what has happened when the sheriff posts the writ on their door. There is a motion to stay the writ that gets filed. Those get reviewed right away. Typically, the clerk's office will notify the assigned judge as soon as those are filed, with, I believe, within minutes, really. And we get that notification by email, and we try to review those certainly the same day, but as quickly as we can to go ahead and make a ruling on that. And then we get the ruling filed so that the clerk can notify the tenant of whether they're going to have to move out or not. And we see all sorts of reasons for these writs. Attorney White, you want to talk about what you see on the tenant side sometimes on these?
Yeah, you'll get all sorts of emergency motions. Some are well-founded. Some are just asking for more time, which is sometimes the very same thing that they mentioned at the final hearing in front of the judge. And so depending on the circumstances, court has to sometimes, make a hard decision on those emergency motions. It's not always, it's better, like you said, Your Honor, that if things can be worked out, the time to try to work them out is either at the final hearing or shortly thereafter. Avoid the situation of where you have to then deal with emergency motion.
Because the moratorium that began, I believe, in April, if I'm not mistaken,
Yes.
These writs were not being served by the sheriff, and I imagine that there is a backlog now from the ones that were issued close to the moratorium. I know I've seen a handful of them, so just be aware that if you are a landlord and you do get your writ issued by the clerk, that it may take some time to get that served, and where the sheriff actually comes back out to make sure it's executed.
I would say that for tenants that may be on this, the time delay that's occurred potentially may be in your favor if you, along the way, were now have worked out an agreement or been paying some rent back to the landlord, whereas the landlord may have been in a position where they just wanted you gone. Time tends to heal all wounds. It's possible if you haven't engaged or had discussions with your landlord or the management, have those discussions with them now before the moratorium is lifted, if it's not extended, because if you are able to work out something, now's the time to try and do that before the writs that may be sitting on a back burner are then issued.
Definitely. All right. I think the last few slides relate to damages. And I know in my discussions with Mr. Kent and Ms. Mullen, we wanted to leave some time for questions. And I think we've spoken with the most urgent needs of people right now, that damages would kind of be on the back burner at this point. So do we want to take questions now?
I think it's a good idea. We do have a question from one of our attendees. She's asking, if you pay the past due rent, can you still be evicted?
Yes.
Yeah. So I guess it depends on how it plays out too. So if you've paid the past due rent and there's an agreement from your landlord that you pay that, then definitely get something filed to let the court know that you've paid it. That may be certainly an issue before setting a final hearing, or it depends on where you are in this procedure, that paying the past due rent could give you more time. But the bottom line is yes, but you have to let the court know what's going on.
See, my answer is always, it depends.
That's right.
Anytime you ask a lawyer something, our answer is always, it depends.
Yeah, true.
The attorney panelists thought that was hilarious. Everyone else thought that was really lame. Fine. Do we have any other questions from Facebook, Charlotte? He's saying not yet. We do have another question on Zoom. What statute covers the repairs and upkeep of the rental property by the landlord?
That is all in Chapter 83. And again, you'll want to go to the section on residential properties. And I want to say 83.56 is coming to my brain, Ms. Mullen or Mr. White.
Yeah, I'm looking up that myself.
There's definitely a part that talks about what the landlord is required to do in terms of upkeep, pest control, etc. And there's a section on what the tenant has to do.
Yeah, the section is 83.51 is what the landlord's obligations are to maintain. And then 83.52 are the tenant's obligations.
Yeah,
And
and the notice requirement, the written notice requirement, that actually goes both ways. So the landlord can give the tenant a 7-day notice of non-compliance saying, you know, you have this dog that you need to get rid of. You don't have approval of the dog. And if you don't get rid of the dog, then your next notice is going to be, I'm terminating your lease. But that also goes to the other side. So the tenant can send the landlord a 7-day notice of non-compliance saying, you're not keeping up. You know, I have brown water. You said you were going to fix that, or, you know, whatever the issue is, or my plumbing is out. And you have 7 days. And if it's something that is considered to make the place inhabitable, then that is a reason why a tenant can terminate a lease.
And if you deliver that 7-day notice with proper 7-day timelines, that can be a defense to an eviction action for non-payment of rent. So you want to make sure you have copies of everything. So.
Yes,
I'm sure
because well, and you know, I phoned the landlord. I told the landlord what was going on. That may be a starting point, but it should be followed up in writing. And then on the landlord side, for those that are on, the 7-day is obviously a ultimate goal for the item to be fixed, but there are some times that are out of control of the landlord. So as long as the aspect of the repairs are beginning and and the landlord showing a good faith effort that those repairs are being made, sometimes they take longer than 7 days. The 7-day portion is really to put the landlord on notice that they have 7 days to begin the process or try to get it repaired in that time frame.
One of the ones that we see in that would be after hurricane damage, you know, where the landlord is like, you know, I've notified the tree man that there's a big tree in your living room. You know, we see these when we have the big hurricanes come through, and the landlord is doing their best to get that resolved. So just like Attorney White said, just be aware of you're just putting them on notice.
We did get another question. This time, I think it's from Facebook. It's, can a landlord change my locks or turn my water off?
Great question. No, that's an easy no. And
that's not, it depends. That's just a no.
Right. I was going to say, that's not even an it depends no. It's definitely a no. That is called a self-help eviction, and that is definitely barred by statute.
Yeah, and the specific statute that deals with that can also be found at A364 under retaliatory conduct. So if a landlord were to retaliate in some way, they can be, you know, damages. I think it's a treble damage situation if they're not careful.
Agreed.
And if something like that does happen, again, you'll want to get to court right away so that matter can be resolved. And unfortunately, things like that occur. And really, the court is the only way to get that resolved.
Do we have any other questions, either through Zoom or through our Facebook Live broadcast?
I would ask Mr. Kent, the clerk's office has a great website with forms and things like that that assist the landlord and the tenant. Can you talk about that a little bit so folks know what's out there?
Yes, Your Honor. If you go to the clerk's website and you can simply type in Leon County Clerk of Court on Google, it'll bring you to the site. You'll see a series of buttons. One of them is called Forms. Simply click on that and you can scroll down, or on the left-hand side, you can see County Court Small Claims. Click on that link. Either one will take you to a set of forms. We have, as was discussed tonight, the 3-day notice to tenant from landlord. We have the 7-day notices, both from landlord to tenant and from tenant to landlord. We have an eviction 5-day summons. We have an interactive eviction process that both landlord and tenants, we'd encourage both groups to look through so they can be informed. We have an eviction process flow chart that was showed earlier tonight. And then we have links to landlord-tenant assistance from the Florida Bar and other information that's available to the public. And we highly encourage people to avail themselves of this resource. So thank you very much, Your Honor.
We did get one more question, and I think it's a very important one, so I'd like to read it off. The question is, I haven't received an eviction, but the landlord is not making a safe space. Can't I just withhold rent? I was told I could.
Got to notice first.
Right.
Gets back to the 7-day notice. They need to notice before they just start withholding rent.
And you have to specifically say what it is about the space that's not safe.
Correct.
Right.
And there is a specific form for that that's on the website, to landlord from tenant to withhold rent. So we'd encourage that you use that form.
Right.
Yes.
And make sure you get copies. Keep
Always.
copies. Always.
Yeah.
I think that the landlord-tenant statute is frankly one of the easier statutes for non-lawyers. So, and comparatively speaking, it's short. So I would encourage you to definitely review that before you either withhold rent, do your 7-day notice. And that goes on both sides, because we see all kinds of things come through that I think just either going to the clerk's website or the statute itself would really help folks resolve.
Great. Yeah. At least the residential tenancies
Right.
portion of it. The rest of it's pretty long.
Yes.
I do believe we are out of time, and I don't think we have any further questions unless I see one pop up in the meantime. But I would like to thank Judge Richardson for coming and, kind of guiding our panelists along. Love to thank Ken Kent. He has been extremely helpful in setting up these clinics and coming to the clinics and giving information on what the clerk's office can do. Thank you very much, Ian White of Ausley McMullen. We really appreciate you coming to the panel and volunteering your time with us tonight. And Femi Lamert from 211 of the Big Bend, thank you for coming and delineating all the things that 211 can help residents of Leon County